Unit 5. Real Estate Sale and Purchase Contract. The real estate sale and purchase contract is a contract whereby the seller commits himself to transfer the ownership of the property to the buyer and the buyer undertakes to pay the contracted real estate price. The buyer is obligated to pay to the seller the entire amount of the contracted purchase price, and the seller is obliged to hand over to the buyer the property in question and to allow the transfer of the ownership rights in the buyer's name. Such a contract, in order to be valid, must be in writing and must contain all the correct information about the property. The signature on the sale and purchase contract is verified only by the seller. It is important to know that the buyer does not acquire the right of ownership by paying the purchase price but by registering that right in the land registry. All persons involved in the sale and purchase of the real estate should be listed with relevant information such as name, surname, address and a personal identification number called OIB, passport, identity card. A real estate sale and purchase contract must be in writing. The real estate sale and purchase contract, in addition to all that has been stated in the pre-contract, usually includes the date of the transfer of the real estate into the buyer's possession as well as the seller's guarantee that there are no third-party rights on the real estate. It is advisable to entrust a lawyer with the writing of a pre-contract to ensure that the buyer is well protected. Several copies of the sale and purchase contract are notarized by notary public. One copy of the contract is kept by the seller, is kept by the buyer, is kept by the notary public, is submitted to the Land Registry Department of the competent municipal court with the proposal for real estate registration, is submitted to the bank if the property is purchased on credit. If the real estate is purchased on bank credit, the contract will be previously solemnized by notary public, and the bank will enter a mortgage on the real estate. When buying a real estate, the seller is required to submit an energy certificate or a copy of it. A down payment is a sign of the seriousness of the business and the real intention of buying a property, and it is usually in the amount of 10% of the value of the purchase price. Down payment is regulated by the Civil Obligations Act. If one party hands over to the other party a certain amount of money or a certain amount of other replaceable items as a sign that the contract is concluded, down payment, the contract is considered to be concluded when the down payment has been given, unless otherwise agreed. The receipt of the down payment is not the end of the legal transaction without the payment of the agreed price. In the case of the full payment of the agreed price, the received down payment has to be repaid or included in the fulfillment of the obligation. The full payment of the contract price is a precondition for the issuance of the permit for land registration, that is, a statement by which the seller declares that he has received from the buyer the total amount of the contracted purchase price, thereby allowing the buyer the registration of the ownership rights regarding the real estate that is the subject of the sale and purchase contract. The permit for land registration is a statement of the real estate owner by which the seller of the real estate, after the receipt of the entire purchase price, permits the buyer the registration of the real estate ownership without any future objections and limitations. The seller, by means of the permit for land registration, authorizes the buyer to obtain, without any further questions and approvals, the registration of the ownership rights in his favor and in his name. The sale of the real estate, besides the transfer of the ownership, also includes the seller's duty to issue the permit for land registration to the buyer if the buyer has fulfilled obligations, that is, has paid the agreed price. If the seller does not want to issue the permit for land registration and the buyer has fulfilled all his obligations, in that case, the buyer is entitled to request the termination of the contract. In this case, the buyer may, by filing a lawsuit, request the issuance of the permit for land registration, a document that enables the transfer of the ownership rights into the land registry, from the seller if he does not want to fulfill his obligation voluntarily. A notary public is a qualified lawyer appointed by the Croatian government. It is his duty to ensure that all documents signed with a notary public are valid, legitimate and legally binding. He confirms that documents in a foreign language have been translated into Croatian by an authorized court interpreter and that they are valid and authentic. He can also offer third-party services in the transaction. In real estate transactions in Croatia, contracts are legally binding only if they have been notarized by a notary public. As noted above, the signature on the sale and purchase contract is only notarized by the seller in the Republic of Croatia and by notary public, while in foreign countries it is notarized in Croatian diplomatic offices. If such a contract is notarized by a foreign notary public, then the authorized court interpreter must translate it into the Croatian language. In the case where the seller of a real estate is the Republic of Croatia, specific rules are applied to the contractual relationship regarding the manner of disposing of the real estate. The Republic of Croatia is the owner of less than 50% of the real estate. The Republic of Croatia disposes of the real estate without a public tender, according to the market value, and according to the location permit or an implementing act of spatial planning. The Republic of Croatia is the owner of more than 50% of the real estate. The obligation to conduct a public tender. A local self-government unit, JLS, is the owner of less than 20% of the real estate. The local self-government unit disposes of the real estate without a public tender, according to the market value, and according to the location permit or an implementing act of spatial planning. A local self-government unit is the owner of more than 20% of the real estate. The obligation to conduct a public tender. The State Property Ministry disposes of the real estate whose owner is the Republic of Croatia. Prior to the realization of a real estate sale and purchase, it is necessary for all the participants in the sale and purchase process to present a personal identification document in order to know who is taking part in the negotiations and whether they are authentic real estate owners. If one of the sellers has an authorization for representation in the real estate sale or its co-owned part, it is necessary to carefully read the content of the authorization and compare it with the data from the land registers, personal identification documents and the OID tax number. If one of the sellers has an authorization for representation in the sale of the real estate, or its co-owned part, and the real estate is purchased on bank credit, before the sale has been concluded with the seller, the authorization must be submitted to the bank and it has to be checked whether the bank will accept it. Immediately prior to the conclusion of the final sale and purchase contract or paying out the purchase price, it is necessary to visit the land registry and cadastre and check the current status of the real estate registration. There is a possibility that someone has in the meantime filed an application for registration, annotation or for any other type of registration of the right to the property in question. It is recommended to check whether an inheritance or enforcement proceedings related to the real estate are in progress. These procedures are often not recorded or are recorded with delays. Related to these procedures, it is necessary to look for registered seals on the real estate. The location, construction and use permits must be certified by a stamp of validity and finality. It is necessary to pay attention to whether on the building for which a use permit or a certificate of the main project has been issued, have subsequently been carried out construction works in terms of reconstruction, upgrading or a new building has been constructed on the cadastral plot. In such cases, a previously issued use permit or certificate of the main project is no longer valid and the actual state must be aligned with that found in the space. Check with the competent state inspectorate that there is no inspection procedure for a particular building. When purchasing an apartment, house or any other property, it is important to check the documentation, a land registry extract, a building permit or other appropriate building permit, a use permit and an energy certificate. When buying a real estate, first, it is necessary to check the ownership registered in the land registry with the municipal court in the area where the real estate is located. Also, it is necessary to request from the owner of the real estate all the documents regarding the building and the land he possesses, as well as the energy certificate. If you are purchasing a property that has not been fully redeemed from the previous owner, usually, state, city, institution, company, ask the seller for an appropriate confirmation of the remaining unpaid amount of debts, preferably with the instruction for the payment of the remaining part until the final settlement. Ask the seller if there is a possibility to take over the unpaid part of the purchase. If one of the sellers is a minor, it is necessary to obtain a written consent for the disposal of a real estate or a co-owned part from the competent social welfare center with the exact amount of the purchase price and the payment instruction. Do not start any purchase without contacting the competent social welfare center. The size of cadastral parcels in land and cadastre registers must be the same, but as in the land register extract in the possession title the equal square footage in M2 must be stated. Identify and compare the boundaries on the parcel, actual situation on the ground compared to what is entered in the cadastre. You can do this independently at your own risk or hire an authorized geodesist. When handing over the down payment, we recommend compiling a document in writing with a witness signature or a notarization by a notary public. Sellers are advised to stipulate the down payment as a cancellation fee. Although the legislator did not prescribe a minimum or maximum amount of a down payment, in practice, the down payment is considered to amount up to 10% of the contracted purchase price. The overpaid amount is considered part of the purchase price and is not calculated as a cancellation fee. Advance payments are not down payments, and such terms are not subject to the same provisions of the Civil Obligations Act. If you are buying an apartment which is still in the process of construction, the investor must provide you with a valid building permit or other appropriate construction permit. Apart from the building permit, the use permit is equally important, but it cannot be obtained if the construction conditions prescribed by the building permit or other appropriate construction permit have not been fulfilled. It is also advisable to request an insight into the main project, which is part of the building permit. It should be noted that the investor, that is the owner of the building, has to obtain an energy certificate before issuing the use permit.